Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It is Tuesday, so that means it is our Tuesday night live show. We affectionately refer to it as After Dark. Thank you for joining us. We appreciate you taking the time to be here. Now, although we will talk about things that I want to talk about, we're obviously going to talk about what you want to talk about. So put it in the chat. We will do our best to try and see your question and answer it. We're not asking for them, but I would note that super chats do get highlighted, and chances of those questions being answered probably go up pretty radically just because I can actually see it as the comments go by. So tonight, I wanted to talk a little bit more about the whole Lori Vallow, Chad Daybell thing that's going on out there in Idaho. And I've said this before, so it's not like I'm just coming up with this to be sensational at all. But I just cannot fathom, yes, this is a death penalty case, but we are now almost 2.5 years into this, and we've done almost nothing. That's the part that is really, what's the word I'm looking for? Frustrating to me, because I know how normally criminal cases work, and they move forward. Judges make them move forward, and this case just seems like the judge never saw a motion to continue that he didn't like or grant. And so here we are. One of the co-defendants, the primary co-defendant, Lori Vallow, not with us. She's still at the state hospital. And we talked about today in our show, so if you haven't, watched it, we put in there the motion that they have, the Idaho Department of Human Services, whoever runs their state hospital down there, has filed another periodic report, okay? My guess is Lori Vallow is not going to be joining us anytime soon, okay? And a lot of people say, well, she must be faking. And we did a show about that there's lots of tests out there that the professionals, the psychologists, the psychiatrists can use to determine if somebody is in fact faking or malingering their mental health issues. And a lot of people say, oh, she must be faking. I just don't think she is. Don't get me wrong. I would love for this case to go to trial. I think it's going to be interesting. It's going to be everything that everyone ever wanted it to be, and hopefully resulting in justice for all involved. But you can't do it if somebody is not mentally competent to proceed. No court in the land is going to allow that. But, it went on for a year where nothing was done or said about any type of issues as it related to Lori Vallow's mental health. And then one day, just as a new attorney was coming on the case, miraculously, he was able to spot, I think that's who it was, Mr. Archibald. I don't think it's a coincidence that as soon as he gets appointed as a death penalty lawyer in the case, that competency issues are raised, because I think he spotted it. Whereas I'm not casting stones, but I just think that maybe the previous attorney, having not done much criminal law, maybe wasn't exactly familiar with sometimes the issues that come out when you have a client that's not competent to proceed. Anyway, she's going to stay at the mental health hospital until she is completely fixed, at least competent. And that's to the point where she can understand who the parties are in the whole proceedings, the judge, the lawyers, things like that. My guess is that's not the basis of the concern. The issue is going to be whether Lori Vallow can assist in her defense. And that's where it gets interesting when it comes to competency type of cases. if you want to talk about all the discovery that's in front of you, i.e. the allegations are that you somehow participated or did something regarding the death of your children, and the only thing the client wants to talk about is how, she is this goddess and the end of the world is coming and everything circles back to them. You're just like, we can't do anything because we can't get past the world coming to an end, right? So, that's the way it is. Here it is. Natasha 007. As a retired psych dimension nurse, it's not easy to fake mental illness. Most people can't keep up a fake diagnosis. I totally agree. And that's why I think the fact that she has been down there now for 6 months now, 6-7 months. If she was faking it, they would have called her on it. She'd be back in the county jail waiting for her trial date. But the fact that she is still at the hospital and there's no indication just as of yet that they're going to transport her back anytime soon makes me think that there's some people that just cannot get restored. It's just the way it is. So then the issue becomes, are we going to go to trial early January of next year, 2023? Can you believe that? But then you have to think it's already April 5th, right? April 5th, 2022. I don't know about you, but it seems like that April came really fast. And for those of you who didn't see the video that we did last week, April Fools, okay? No one's retiring. Nobody's staying home to take care of Miss Winnie the Bulldog, okay? It was an April Fool's joke. Like I said, I've had a job since I was 12 years old. I don't know what I would do at home for more than about a day or two, maybe 2 weeks at the most. So yeah, not going to happen. So anyway, we digress, okay? And so now the issue is going to be, let's just assume Lori Vallow is not competent to proceed. Maybe there'll be a competency miracle. Ta-da! Suddenly one day she is competent. Okay? Think about that. Maybe that's... Then we have a trial date set in January. Well, she hasn't even been basically arraigned. Now, if she were to become competent, I think the judge could, under speedy trial rules, delay the start of that trial. I think he'd probably force Mr. Archibald to get ready beforehand. Hopefully Mr. Archibald is preparing to, do a trial, if that's the case, if his client is restored to competency. But if she is restored to competency, how did they do it? Usually it's lots and lots of drugs. And usually it's some sort of get them high enough doped up on drugs so they can get a guilty plea done, and then we'll ship them on their way, off to the next jurisdiction, so to speak. So we'll see. But let's assume for this scenario, Lori Vallow doesn't join us. She's not deemed competent, and we have a trial, okay? The state of Idaho, the people of the great state of Idaho, and I get it. Hey, inflation sucks, man. Inflation sucks. It's expensive. But I was looking at the supplement that the people filed, as well as their updated supplement about the costs that they are going to incur. And they keep citing to Idaho Code Section 19-1816, okay? And that's the whole Section 19 of the Idaho Code, beginning at 1801, are the grounds for removal, okay? Change of venue. And it says a criminal action prosecuted by indictment may be removed from the court in which it is pending on the application of the defendant on the grounds that a fair and impartial trial cannot be had in the county where the indictment is pending. Makes sense. The judge has done that, okay? And, there's certification of costs, basically. The clerk of the court in the county in which such action is or may be removed must certify the amount of said cost to the auditor of the proper county, which must be allowed and paid as other county charges. Makes sense, right? And then there's this one section, the last section, 19-1816. There's all this stuff about, removal, state orders, transfers for cause, appealing, certificate of cost, etc. And then there's this one little add-on thing. And I'm not sure what year it became effective. It looks like 1983 in Idaho. Somebody added it on, and this is what the statute that the prosecutors are relying upon. It says, as an alternative to entering the order of removal provided in the preceding sections of this chapter, the court may instead enter an order directing that jurors be impaneled from the county to which venue would otherwise have been transferred if it finds, 1, that a fair and impartial jury cannot be impaneled in the county where the criminal complaint, information, or indictment is filed. The court has already found that. The court has already determined, made the finding of fact, conclusions of law, that neither Lori Vallow nor Chad Daybell could receive a fair trial down there in Fremont County, right? Fremont and Madison counties where the charges were originally filed. Second, that it would be more economical to transport the jury than to transfer the pending action. And third, that justice will be served thereby. And then it says under subsection B, the jury shall be summoned and impaneled as if the trial were to take place in the county where the jury was summoned. Thereafter, the jury shall be transported for purpose of the trial to the county in which the complaint, information, indictment is filed. All court costs incurred under this section shall be paid by the court where the complaint, information, or indictment is filed. The provisions of this section do not affect the power of the court to order a change of venue. That's what they keep hanging their hat on. And basically their argument is, Judge, this is going to be difficult for the prosecution. And don't get me wrong, when you're in trial, the one thing that you want to be able to do at the end of the day is go get in your own bed. But I just don't think having it in the comfort of your own jurisdiction is the good reason, okay? Everyone in the jurisdiction is entitled to a fair trial. You also have to consider the jury, okay? And if anyone's ever been on jury duty or been to court and you watched a jury trial, what is the one thing the court is always concerned about? Is it that the defendant is comfortable in his chair or her chair? No. Is it that the counsel and the prosecutor or defense counsel have enough pitchers of water on their table so that they're comfortable or that they can hear properly? No. They don't want to keep the jury waiting because they know that these people are being inconvenienced, taking time out of their busy schedule to fulfill their civic obligation to do jury service. Okay? Well, if this case is done in Ada, Idaho, those jurors, guess what? They get to go home, see the kids at night. They get to go see their spouse, significant other, tuck the kids in at night, okay? Sleep in their own bed. Versus, under the prosecution's plan is, let's inconvenience the jurors, not us, the prosecutors. Because, we're going to have to get, space and travel, and it's going to be, their biggest argument is it's expensive. And I get it. But guess what? That's what prosecutors do. They're supposed to, take these cases and move forward. Now, in their first filing, the people said it was going to be some $269,430. Well, they have since updated all of their numbers. Miss Lindsay Blake, the Fremont County prosecutor, and Madison County prosecuting attorney Rob Wood. Okay. And remember, district attorneys don't have a stash of money. They usually get that from the county or the state, depending on how their system is set up. Most of them, it's the county thing. So they got to go to the county to do this. So they prepared this nice little PowerPoint. That's right. Death by PowerPoint. It's a thing. Anyway, so they want to call all these witnesses to reiterate what they're going to need. They're going to need 14 personnel who have to go to Ada County from the sheriff's office to cover the trial. Personal duties include bailiffs in the courtroom, transportation to and from the jail, transportation, security of witnesses, assisting courtroom door security, jury transportation, security, and sequestration. And they break that down. They basically say the full change of venue to Ada County, $269,430. If just the jury selection is done in Ada County, it's $53,444, saving the difference just from the sheriff, $215,986. Well, then we got to add in hotel, right? $60,000 per month is what they're estimating. 14 staff at a nightly rate of $147, must be, government rate or something there, times 30 days times 4 weeks. For sequestration in Ada County, would need to hire secondary female to provide support in Ada County, so they'd have to hire additional female officers. They would have to rent 2 large rentals, $30,000 to $40,000 per month for the number of people involved in large enough that they can reserve the space. They've broken it down to parking costs, $10 a day per vehicle, 3 cars times 5 days times 10 weeks times $10 is $1,500 just in parking fees. Really, there's no public parking in the courthouse? I thought that was only in Denver, where they build a courthouse in the middle of the city and don't put up no parking. But hey, you never know. And of course, the gas transportation, 340 miles to Boise at 20 miles per gallon, 17 gallons per car, basically $3,700 in fuel costs. Meals, they're estimating it's going to cost the 14 people $51,000 in meals. Okay, sounds like pretty good per diem. Overtime costs. Estimated cost for overtime for a trial in Ada County over 3 weeks, 3 months, $63,000. They got to pay for the jail, transfer of Chad and Lori Vallow, Daybell, fixed rate $55 a day in other counties, costs by month. Basically, that's $4,950 for the defendants to be there for 3 months, $9,900 for both defendants. So they're breaking it down for just Chad, or if they're both there. So the costs go up, and that's their biggest thing. Hey, I get it, man. Trial's expensive. So then the court clerk had to break theirs down as well. They attached a nice little PowerPoint as well, basically saying here's all the government rates, prosecuting attorneys, staffing. They're going to have to get another district attorney because they only have 2 district attorneys, and they're going to have to all be up there working. So who's going to be prosecuting the cases while everything's going on down there? Hey, justice is expensive. What can you say? It's a death penalty case. My humble opinion, advice would be, hey, I get it, but you want to do this case once, twice, or 4 times, right? If the defendants are severed out, if there's multiple trials, if you want to give the defense anything to raise on appeal, do it this way. And I know the statute says you can do it and you can consider cost, but it has to, the judge has to look at the justice will be best served thereby. I think the argument would be that there's a taint when you have these jurors that are sequestered in Fremont County. They're going to know it's all about it. And I'm like, I just don't know why they're messing with it. I guess the judge is going to make his hopefully hear it, but I just don't think the cost and the convenience to the district attorney is necessarily their problem. And I get it. Taxpayers don't want to pay for this stuff. But like in a business, you've got overhead expenses, right? You've got overhead expenses. You got to have the place that you can have your office, the utilities. There's stuff you just got to do. Well, in the criminal justice system, it's the same way. It's not like you get a return of your investment on police officers necessarily, right? Yes, they protect it. They make the city safe. They make people want to move there, so they're worth value of that. But it's a cost of doing business, right? And the government has one job, and that's basically to protect your rights from other individuals taking away your rights. So having a police force is the cost of doing business in the state. It's just the cost of it. So I think that they need to get over the cost. I did a trial a couple years ago. It was a double deceased baby case, right? And I'm here in Denver. Case was originally in, gosh, I can't even remember the trial, but wherever Telluride is. Beautiful, beautiful town, city. And we got moved to Montrose, which nice enough place, but it was going to be a 3-week trial. We were expecting 1 week just for voir dire. We brought in 600 jurors, right? Because they said, oh, it's a small community, but we can try to find it. And sure enough, we found them. But it was inconvenient. Now, myself and I had another attorney do the trial with me, and we rented a house for 3 weeks, which was better than going home to a hotel any night, And we did that. It was nice. You could stretch out. You could, have your separate ways, so to speak. But we were also able to fly home. In fact, we did that, I think, twice until we had a negative experience. We were getting ready to fly back and had an engine issue as we started heading out over the mountains. But we digress. Yeah. Oh, Carrie has a good point. They didn't seem to have an issue with money when they brought in the new prosecutor. That's true. Jean, I think that's Jean or Jean. Lori will be restored right after Chad's trial, possibly. Yeah, I'm not sure about that. I think depending on how things go for Chad's trial, she may want to not be competent ever. Okay, but yeah, we'll see. And Honey Badger, Lori wasn't crazy until she got caught. How convenient. I get that. I get it. I do. I get people's skepticism of it. And if I don't have any personal knowledge of Lori Vallow. Okay, but I have dealt with people who have been deemed incompetent, okay? And you talk to them, and they look normal, right? We've talked about this, right? What do you normally think when somebody, the crazy person, right? It's the guy with schizophrenia, homeless, walking around in the snow with no shoes on, dirty, beard, right? That's the crazy guy. Well, I've seen people that have been deemed to be incompetent that look normal. They talk normal. And I'm telling you, it is a bizarre thing. And I had a case once where I was like, man, this guy just can't assist in his defense. What am I going to do? And, ultimately have to have him comped. And they're like, yeah, this guy looks normal, no history whatsoever, but he truly believes particular things. And I've also had things where like, wow, this guy's crazy. The stuff these people believe in, this is nuts. But having strong held beliefs about something does not necessarily make you crazy unless it completely makes you delusional in the sense that you kind of believe your own BF, so to speak. But people believe all kinds of stuff, ladies and gentlemen. So you just have to be very, what's the word I'm looking for? You have to trust the professionals on this one. And if the professionals are saying Lori Vallow is not competent, I'm telling you, the professionals down there at the hospital or up there where it is in Idaho, you got to trust them on this one because they know malingerers. They can spot malingerers. nobody can malinger for 7 months, even if your life depended upon it. Okay. You're going to do something. And that's what and maybe one of our viewers can chime in here. But when somebody goes down for a competency evaluation, what's the word I'm looking for? They are monitored by everyone, okay? They're being watched when even the person doesn't think that they're being watched, to see if they basically relax and like, oh, they're not watching. Oh, boy, that's great. It's very, very difficult, okay? And so I think that, we'll see. This is 0. So if you're guilty, there's no defense to assist with. So what? Actually, 0. I respectfully disagree. Okay? And everyone, whether you are wrongfully accused or guilty of sin, everybody is entitled to a lawyer and a defense. And in the United States of America, you can be guilty of sin and you can say, guess what? Prove it. That's what our legal system says. Prosecutor, prove it. If there's a guilty plea, it's saying basically, you don't have to prove it, prosecutor. I'm going to enter a guilty plea. But if they say not guilty, go to trial, prove it, they being the government, has to prove it. And I know some people may not like this, but hey, this is the defense attorney's side coming in here. It doesn't matter what you did. It only matters what the government can prove, okay? I know, you've seen those memes like the billboard. It doesn't matter if you did it. It only means if they can prove it. There's some truth to that, okay? From a defense standpoint, the Vallow Chad Daybell matter, it's defendable. Sure, there's problems. Don't get me wrong. If you're Chad Daybell, you've got the remains of 2 deceased children buried on your property. That's a problem. That's what we refer to in the business as a bad fact, okay? Good facts, right? For Chad Daybell, if we're kind of just brainstorming it here, right? Good fact for Chad Daybell. Lori Vallow, crazy, okay? You know how many times we would love to be able to go and say, dude, the other person that did it is just bat blank crazy, right? Well, now you can. Ladies and gentlemen, everybody's going to know she's not there. She's at the state hospital. They're going to say crazy. They're not going to use fancy words like incompetence. They're going to say she's not there. Then you got deceased brother Larry Cox, who I think most people would probably say he's the one that probably did the terrible things to both JJ and Ty Lee. But he's now dead too. Okay? And I'm just telling you, from a defense perspective, there are things that you can do with this case. It is not all for naught, so to speak, for the defense side. Don't get me wrong. There's an uphill battle. The biggest thing is, I think, and the evidence that we know so far, obviously Chad Daybell, his biggest problem, he's got the deceased remains of the children on his property. Bad fact. That call where Lori Vallow calls the day that they find the remains, and he's like parked across the street, and she calls, hey, what's going on? And he's like, yeah, they're there, and I'm paraphrasing, they're getting warm, right? And then he starts driving away, and then they go and arrest him. That phone call, devastating. And this is why when they say anything you say can and will be used against you, so many knuckleheads out there believe, well, it only matters what I say to the police. No, it's anyone. Hence the rules of evidence. Anything comes in by, it's called an admission by a party opponent. So when it says the people of the state of whomever, or the United States of America versus blank blank, anything those people have said to anyone, as long as it is relevant under the rules of evidence. What is relevant? Does it go to prove or disprove a material element of the offense? It's relevant, right? It's an admission by a party opponent. It comes in. Just got to get over that threshold for relevance. But I think Chad Daybell's, thing, like, hey, what's going on? He flees the scene, consciousness of guilt. So you've got stuff to work with, okay? His greatest defense is going to be that Lori Vallow's not there. And he's going to point the finger, based upon what I know, if it was my case, I would be pointing the finger all day long to Lori Vallow and her brother, Alex Cox. That's what I'd be doing. Ladies and gentlemen, I had no idea. She fooled us all. Look at her. She's fooling. For all we know, she's down there fooling those people. That's how good she is. I've been duped. And he's going to say, of course, he didn't kill his wife. We still don't have the autopsy result. I'm surprised that something like that has not leaked into the public domain. You got to admit, somebody's got that under a really tight leash there. But yeah. So no matter how desperate or overwhelming you think the case is, you still have to have somebody commit or be able to participate in their defense. So 0, as it relates to your statement, if they're guilty, there's no defense to assist with. Absolutely not the case. In actuality, the more overwhelming the evidence, the more participation in the defense you often have to have. Consultation with experts and things like that. Just look at the Letitia Stout case there in Colorado Springs, where she's on trial for Gannon Stout. How many experts? How many times she's been back and forth? So yeah. All right. So there we go. Wow. Let's see here. Let me ask you a couple more questions. Leah, Scott, did you hear Mark Means fled Idaho? He's now in Missouri, apparently. I had not heard that. Jenny D, praying that you're wrong, Scott. Sorry. I think he's going to throw her under the bus any day now. Yeah, ladies. Okay, Kelly's saying that the kids say that she was suffocated, referring to Tammy Daybell. We'll see. They exhumed her body, and I'm no pathologist, but what was it, a year or something like that from the time that she was passed away, buried, and then exhumed? I'm not sure they're going to be able to do that. I've had some experience with that, basically with bodies and things like that, and even had to consult people like the body farm kind of stuff based upon all the stuff that's in the surrounding area of the remains. How can you tell? And as time goes by, you can't really tell much of anything. So I don't know. I don't know. Cat, my grandson also has schizophrenic, takes his meds and does live a normal life. That's right. You gotta do that. Yep. Okay. Kelly said it was leaked suffocation. Okay. I hadn't seen that. Maybe I didn't. Maybe I don't recall that. But someone will be able to tell me. I don't think Chad was his home, right? Wasn't he off on like a book tour or something? I don't know. Chad's kids say he was framed. Let's see here. I'd be there a bit more of the rain. Let's see here. Let's see here. I'm just looking at this, some of the statements. Yeah, people are like, throw him under the bus, throw him under the bus. Yeah, John Pryor, who is, in my opinion, a very strong lawyer, this is clumsy clairvoyance, has already alluded to the fact that they will be pointing their finger at Lori. I mean, yeah. I mean, you have to, right? The threat of imminent incarceration tends to break the bonds of loyalty, ladies and gentlemen. I mean, I'm sure Chad Daybell has sat in that jail cell for the last, year and a half now, and probably done a lot of reflecting upon the last year and a half. And he probably, he met Lori Vallow at this book tour. Like, okay, yeah, she was great. She rocked my world. This was a lot of fun, but I didn't sign up for basically winding up on death row, right? So he's thinking, I didn't do this. I'm not pleading guilty to it. And I'm sure he's one of those men of conviction that'll say, by God, I am not pleading guilty to something I didn't do. I didn't do it. Blah, blah, blah. I'd rather spend the rest of my life in prison than plead guilty to something I didn't do. I can admire that. But it means we're going to trial. And if he's wrong, guess what? He's going to death row more than likely. But in the meantime, throw Lori under the bus. That's what he is going to do. Well, if somebody leaked the autopsy report, feel free to, if somebody has a copy of that, let me know. Mari Scott, why would they hold a scheduling conference in her case if her case is stayed? It will depend. Sometimes they'll hold it. It'll be more than likely outside the presence of everybody else, but it's probably just to get an idea as to what's going on. Obviously, if the report says she's been restored, it has been a restoration miracle, then let's have a status conference. How much time are you going to need for Mr. Archibald to get ready? You better go visit your client. I don't think that's the case. I think it's more of a scheduling. And I think the scheduling conference, I don't know. We'll have to wait and see. Last time I looked, I didn't think there was a scheduling conference scheduled. There was the one on the 19th. That's the one where they're going to do the whole hearing regarding the change of venue or removal, as they call it, in Idaho up to Ada County. We'll have to wait and see. Let's see here. Forensic anthropologists can detect a lot. They have access to far better equipment than the PDs and the pathologists. They do. I've retained forensic anthropologists before, consulted with them, particularly when you have remains that are just, what's the word I'm looking for? They've been out in the weather, so to speak, for a while. There's no obvious signs of, there's no signs of somebody was being shot. There's no signs of stabbing, scrapes on the bones, things like that, things that are obvious that the doctors could look at. So that oftentimes you need to, the forensic pathologist can try to age things and what have you. So, yeah, it's good stuff. Yeah, Jenny. They kind of had their window, and they really didn't do that. Crime Curious, she states, they wanted to be together so badly that a handful of people had to die. Now they don't want to be together. I'm pretty sure a jury of 144,000 would find them both guilty regardless. I'm not saying he's going to win, okay? I'm saying you got some stuff to maybe create a little bit of reasonable doubt, maybe, but is it going to be so enough for a not guilty? I don't know. We'll have to wait and see. Really what this case comes down to, in my opinion, is, remember, the defense doesn't have to do anything, right? They can sit there and play solitaire if they wanted to. Play cards with the defendant and the attorney. Now, that's not going to happen. That would be disrespectful to the proceedings. But in theory, that's what they could do. They have to do nothing to prove their case. And some people don't like Mark Pryor, John Pryor, I'm sorry. Always people say, oh, I just don't like him. He seems kind of smug. And he may have his issues. I get it. You're not going to please everybody. But I don't think he's stupid. And I don't think he's a bad attorney. At the preliminary hearing, the case wasn't going to go away, but he made a couple of very good points. And remember, he let Mark Means take the lead on the ridiculous stuff. He maybe joined in at the end of it. It was Mark Means that was going out there. It was like, yeah, you go. I'll join. Made his arguments, things like that. But he seems like a pretty seasoned trial attorney. And don't ever underestimate that. And, if you get a jury from a different jurisdiction. Now, Frank and I, we hopped in CrimeTalk 1. Gosh, that was still during COVID, right, Frank? Yes. It was kind of early COVID, I think, right? Last summer. It was last summer. That's right. We took Frank and his dad, and we went out to Rexburg, Idaho. Got some good tips on the airport to fly into. Wasn't bad. Had a car rating. We drove in, had some lunch, checked it out. People seem very nice. The town is spotless. I mean, it looked like something, drop out of Central Casting, Middle America, USA. I mean, I can imagine the 4th of July parades. I mean, it's probably like something out of a movie set. I mean, that's how wholesome this city is, okay? I mean, the people were absolutely wonderful. Very, very nice. And just like everywhere you go in Utah or Idaho, or at least, like the major cities, where there's a predominant, Mormon presence there, the place is spotless. Right? Did you notice that, Frank? Yeah. Do you remember that? It was like the place was spotless. Yes. Spotless. And like I said, the people were very nice, and they are all like, oh, everybody knows about it. Everybody's talking about it. So it was a no-brainer that the judge said, there's no way we're going to get a fair trial here, right? And so, I don't know. You get a jury that it could go both ways. One of the things people say, oh, you can't have a jury down there because there's a lot of people that are, Mormons, and, they won't have a fair trial, blah, blah, blah. But you get out of that. I mean, someone maybe can tell me up in Ada, Idaho, I don't think there's a greater presence of the Mormon teachings down there. And so you never know what a jury will do. They may say, bunch of crazy people thinking the world's going to come to an end and the world, and blah. I mean, they're just going to look at it and be like, what the hell is going on, right? And they're going to say, all this stuff happens on the weird eastern part of the state, right? Because the western part of the state is where everybody from California moves, and you just never know, right? We'll just have to wait and see. Jenny X, incompetent is not together enough to sit in court and understand you are on trial for murder. Insane doesn't know right from wrong. Very, very true. But you still got to be able to persist in your defense. I think he's sleazy, the type of guy I wouldn't trust my daughter with alone in a room. I hope they're referring to Mr. Pryor, which said that, not me, Scott Reich. But okay. Oh, somebody here says, I've met John Pryor. Oh, let's see here. Where was that? Then as soon as I touched it, it scrolled up. Where did that go? Sorry. Gene, Pryor's not death penalty qualified. We've gone through that before as to what makes a death penalty qualified attorney. And he meets the qualifications. Miranda Heim, hope I pronounced that correctly, says, I've met John Pryor. I thought he was very personable and nice, very smart. That's my perception of him. Some people don't like him. Like, oh, he's cocky, blah, blah, blah. I can imagine what people say about me when I've been in court. I mean, I've had people tell me, oh, I wonder what Mr. Reich has to say about that, right? That's what, I've heard from jurors. Oh, yeah, we knew when Mr. Reich stood up. I wonder what we're going to hear about him, hear about that, what he's got to say about it. So I don't underestimate Mr. Pryor, okay? He seems to be very competent. Haven't seen Archibald work. He usually just kind of sits there on the screen, so I can't say, but he's a death penalty qualified attorney there in the great state of Idaho under their requirements. He was appointed because he's had death penalty experience. So he's gone to trial, okay? He may be very technically and tactically proficient. I don't know. I haven't seen anything from him yet. Jenny D, it's just my impression I get from watching him in court. Perhaps he's a very nice person. Yeah, I mean, I've been accused of being not so nice person in court. I always try to start off very nice. But I've been accused of being not so nice when people want to play games on the witness stand or something like that. He's doing his job. I mean, I think that's the thing you have to remember is he's doing his job. And kind of going back to it, I mean, if you had to put bets on it, was he going to win or lose? You'd probably have to say Chad Daybell will more than likely lose, okay? But the prosecution can screw this thing up, right? And frankly, I mean, Mr. Wood seems like a very competent guy. The new lady, was it Miss Blakely, I think is her name? Miss Blake, sorry, Lindsay Blake, sorry. She seems nice enough. I think she very, I'm not sure what I'm looking for, because I got accused of saying, because I said, wow, I mean, her argument sounded like, she was rehearsing for, some sort of law school, moot court competition or something where she had to make sure she made all of her points. And it's like, I think you're kind of winning. Like, one of the things you have to learn when you're an attorney is when to sit down, right? And she just kept talking and going over the same point over and over again. It's like, God, what is this, moot court or something? Like, you're a law student. You have to make sure you hit all your points. And, boy, some people are like, you're only saying that because she's a female. No, I would have said that if a guy was doing it the exact same way as well. I mean, don't make the judge. I mean, the judge can read the law. He's read the briefs. Most of the time, and everybody thinks there's lawyers that are going to get up and make these brilliant arguments and going to sway people, etc. Most of it's done in writing, right? That's what most people don't realize. When you go to law school, you become a writer. That's what you are. You write things. And who can be the most persuasive writer is usually what's going to win the day. I mean, at this point in my career, I'm like, Judge, I think we briefed the issue. I could sit up here and repeat what I've put in my brief, but if you have any questions, let me know. And I mean, I can reiterate, I know all the points. I can argue them, but you're a federal judge or you're, district court judge. I'm assuming you've read this stuff. If you got any questions, let me know. I mean, they'll usually tell you I framed the issue and this is what I want to focus on. And that's usually all done pre-litigation, so to speak. So, yeah, I don't know. So anyway, Ms. Blake seems nice enough. I just thought the one day she was making an argument, it was going on and on and on. I was like, the judge, you could even see, he's like, are you done yet? Like, stop, please. Please stop. So it's nothing against her. I would have said that about anyone who would have gone on making that style of arguments. Like, I must make all my points. I must get them all in. Even though the judge is looking at me like, I have a third eye on my forehead. I must keep talking. I must keep talking, right? Don't do that, right? Sometimes judges will tell you, I have one question, very specific. This is the issue I want to frame it on. Or my personal favorite. The judge will say, there was a judge once, I loved this guy. He was the best. He just got it. Been on the bench for like 35 years. And okay. Oh, sorry, I got distracted by a comment that popped up here. The judge would say, I'm inclined to go along with the proposed disposition, usually like probation, unless somebody wants to say a word and talk me out of it. I mean, that's the judge's way. It's like, we got a lot on the docket. What do you want to do? Judge, I got nothing. If you're inclined to go, I got nothing to say. Bring it on, right? It's one of the things you got to learn. Because I've literally seen something where somebody feels like they have to get up and start talking, because the client's paid them a lot of money and we got to go talk about, and literally they talk themselves out of probation. I've seen it. That's one of the things, and I'm just me, my own personal observation. Okay, I've said this before. Anybody can go to law school, graduate, and be a lawyer. You can have a litigator, right? That's mostly civil guys and ladies, where they litigate, go back and forth, they nitpick. Oh, you did this. Gotcha, nitpick, right? And then you got trial lawyers, okay? Trial lawyers are people that can sense the room, can feel what's going on, quick on their feet, okay? Little, boom, boom, quick on their feet. Because in civil cases, it's also rehearsed, right? Everybody's taking the bazillion depositions, blah, blah, blah. Criminal cases, you don't get to do that. Most of the time, the witnesses aren't going to talk with you. First time you get to talk with them is on the witness stand. So you got to have an outline of what you're going to do. I want to get this point, A, B, C, D, and E, right? I'm going to get those points out if it's the last thing I do. Sometimes it doesn't quite exactly go the way you want it to because they're fighting a little bit. So you got to work with them a little bit. All right, let me understand this, right? You had to be able to be quick and change and know the facts of the case. And no disrespect, but not everybody can do trial work. I know attorneys that are terrified of public speaking, that cannot, will not, do not want to get up in front of a jury and talk, which I think is odd. Because don't you think most people think that's what lawyers do? No, most of the time lawyers write and write some more and write some more. So you got to be able to do the whole deal, right? Be quick on your feet, write, and get up and talk to people. So we'll see. I think Pryor's been around long enough. He's a trial lawyer, okay? This is the case for the prosecution to lose. And they know it. All right? And what do prosecutors always do? Show of hands. Does anybody know the answer? Oh, not seeing it. What do prosecutors always do? They overtry their case. Okay? They overtry their case. What do you mean, Scott? Simple rule of thumb. Do you want one good witness or 4 lukewarm witnesses? You want one good witness, okay? Because those 4 lukewarm ones are going to say something, they're going to screw it up. But what do prosecutors do? Instead of calling that one good witness, they call 4. Because they say, we've got a heavy burden. We have a heavy burden of proof beyond a reasonable doubt, a burden that we gladly accept, blah, 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 blah. And then they overtry their case, okay? And just like you defense attorneys will tell their client, shut your mouth, less is more, prosecutors don't get that rule. They don't figure that out until they've gotten burned. They're like, I had such a good case. I had 5 witnesses. Yeah, but they all said 5 different things, right? And that's doubt. I'm telling you, true story. I can remember it like it was yesterday. Had a great judge. She was a great judge. And it was nothing. It was a fight at a quinceañera, okay? And my client was accused of punching somebody at a quinceañera. Family event. Somehow, no one even knows what they were fighting about, but there was a fight. Usually alcohol was involved. Anyway, the DA could have called one witness, the guy that got punched and had like the broken nose, right? Serious bodily injury felony. He could have got up and said, yeah, that's the guy that hit me, right? Did they stop there and win their case? No. Because I was going to put my guy and say, well, if I hit him, it was in self-defense, right? But they kept calling these 4 other witnesses. Oh, well, it could have been him. I don't know. There was so much going on. It was crazy, blah, 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 blah. Complete chaos and confusion. Prosecution rests. I used to get up and say, Your Honor, the defense rests. Prosecution gets up. All right, so maybe we don't know exactly what took place, but we do know is that there was a fight, and he was more than likely the one that did it. And I remember the judge kind of looking at me. He kind of had that smile, like, yep, I got it. I heard it, Judge. I heard it. So I get up and I say, ladies and gentlemen of the jury, if the prosecution, now seated over here at the counsel table, doesn't know what happened, how do they expect you to know what happened? And guess what, ladies and gentlemen? That's reasonable doubt. And I sat down. Whereupon the jury promptly found my client not guilty. And one of the jurors asked and said, hey, I got a case going on, or a family member. Can I get your card? Okay. So just anticipate. Is it the prosecution's case to lose? They will do it by over trying the case. They need to keep it simple. And if they can't clearly explain what happened, who did what, the defense is going to get up and say, ladies and gentlemen, if the prosecution doesn't know who did it, how do they expect you to do it? To know who did it, right? And so the prosecution's going to have all that figured out. If it was Alex Cox that did it, they better be able to tell who did it. Not, well, we know they're dead, and they all had a meeting. They were talking, and after that they were all deceased. No, they need definitive answers for that jury that's going to go in there with a skeptical mind. Remember, these jurors will have been selected because they stated that they were willing to give both sides a fair shake, to give the presumption of innocence to the defendant in the case, which means not argue or give the other side a head start. Basically, we talked about it last week. I think I love my example of presumption of innocence, right? And that's what you have to do. Basically say, I don't believe it. Because if there's jurors that say, oh yeah, those two did it over there, they did it, they're bad people, they did bad things, they're not sitting on that jury. It has to be people that say, yeah, I can give them the presumption of innocence. Government hasn't presented any evidence whatsoever. If I were to have to take my vote right now, the vote would have to be not guilty because they haven't presented any evidence whatsoever. So, normally what you think is going to happen at trials happens, but there's always that exception to the rule. And it's always done by experienced defense attorneys that create something out of nothing, okay? And I don't know how long Ms. Blake has practiced law, or even Mr. Wood. I'm not familiar with their numbering system, how long they've been. Their Idaho State Bar number, Lindsay Blake, 7920, Rob Wood, 8229. I'm guessing they probably practiced, 20, 25 years. Hopefully they've done lots of trials, and they will keep it simple. They got to keep it simple, straightforward, and have all the answers that the jury is going to ask. Who did it? Who did it? All right. Donna, quick question here. Let's jump to the Barry Morphew matter. Scott, in the Morphew case, where has DA Stanley disappeared to? Now there's another DA from another county taking over the case. Is that allowed? Shouldn't a hearing have to happen for that? No. Prosecutors are fungible, right? Fungible. Which means they're replaceable, right? You can just take one off the shelf. It's like when you go, you buy a generic item at the store. They're fungible. You don't care which one you get. They're fungible. You can't. The defense attorneys have to stay on there because they know the case. They have the facts, attorney-client privilege, all that kind of good stuff. DAs, they're fungible, right? Now, I love making that argument. Judge, the defense is ready to proceed. It's not my fault that the district attorney has found themselves scheduled in multiple courtrooms and unable to proceed today. But as they say, Your Honor, DAs are fungible. They could probably get somebody in here to try this case, right? Who's unfamiliar with the case? Overtry it. That's right. It's good stuff. Had that happen not long ago where the judge's like, you're going to move to continue, right? No, I'm ready to go to trial, Your Honor. Let's do this thing. They transferred to a different courtroom because that judge had a conflict. The DA had the other case up there as well, so they brought in somebody else who's fungible, not familiar with the case. Not guilty. Yes, that's right. So they're fungible. DAs can bring in anybody. Where is the good district attorney? I do not know. You would think, though, this is the biggest case that she's had in her career, and particularly as a newly elected district attorney. Maybe got a little over her skis when it came to prosecuting this case early on, at least according to the former lead investigator, who she basically fired because he didn't like his opinion. I think I'd probably disappear too. Let's see here. Let's see. He was punished by the court. He may have lost his license in Idaho. A book could be worth more than his law practice. I really don't know what he's thinking. I'm assuming that's Mr. Pryor. Yes, he did have that misdemeanor conviction for some sort of harassment of some sort, I guess. But he has a law license now. Jody Harris, defense attorney, wrote a book and was disbarred. Yeah, unfortunately, you can't. I mean, it's revealing attorney-client privilege. You can't do that stuff unless. I mean, even then, you got to get a waiver. I mean, you can't do it. I mean, I remember years and years ago. You had everything was in paper form. Now it's all digital. I literally had a storage locker full of cases, like 15 years worth of boxes, saved everything. And you'd forget about it. You're like, oh, yeah, this case. Oh, that was a crazy one, wasn't it? Oh, man. Oh, here's the one we wound up on the front page of the Denver Post. Wow, look at that. Oh, wow. I mean, you just so many stories you wish you could tell. But you can't. Mark Means makes, probably not. Let's see here. All right. Wow. Look at that. It's already 7:05 Mountain Time. Well, I hope you all enjoyed the show. But guess what? If you'd like to continue the conversation, look at that. We had lots of people tonight join. 910 of you. Hopefully you enjoyed it. I love you, but so biased. They said he was already leaving for a different job, Mr. Reich. Bias? I just tell you the way it is. But I tell you, if I'm going to say, okay, I'm going to put on my defense attorney hat coming on. But like I said, what reason? I don't get any more stuff out of pitching one way or the other. I mean, you want people to, I'll tell you the good, the bad, and the ugly. I mean, I think the prosecution's got a little bit of a problem. Let's face it, I think Chad Daybell's got a problem. I think Lori Vallow, maybe not going to be competent. Maybe she is. I don't know. If she is, maybe she cuts the deal once she realizes what she allegedly may have done, right? Oh, super chat. Let's see here. I didn't see it go by here. Let me see. Oh, there it is. Sarah, where is the line between attorney-client and co-conspirator if an attorney actually aids their client misconduct and in and outside of court? I realize this is a civilish question, but am curious from your perspective. Well, there is a, what's the word I'm looking for? We talked about a story yesterday, wasn't it, Frank, where the attorney who she was representing on a basically domestic, the attorney, female attorney, was representing the client on a little domestic dispute where he allegedly, I think, punched and strangled his I think it was his ex-girlfriend or something. And the attorney goes over there with him, and they basically, well, they kill her and her parents that are in the house as well. And now they're being charged with 3 counts of intentional murder and the death penalty. Now, that clearly crossed the line, okay? And that is a situation where the attorney was clearly a co-conspirator. Clearly. But if, I mean, you have to remember, I mean, this is the thing. How's the word? How do I want to say this so that it doesn't come across as wrong? If a client comes to you and says, "Hey, I just did a bunch of terrible things and there's a bunch of bodies buried over there." Okay, there's an attorney-client relationship. You cannot reveal that information. Okay? And if the client then says, "Hey, I want to go dig up those remains and move them, and so they'll no one will ever find them." The attorney can't say, "Hey, great idea." That would cross the line. The attorney should say, "No, you shouldn't do that. You shouldn't move, tamper with it, whatever." But let me tell you another little secret about lawyers, right? No one ever listens to us, okay? No one ever listens to us. I know you may find that hard to believe. Like, Scott, you've been doing this for a long time. You charge people large sums of money, and then what you are saying is that they don't listen to you? Yes, that is what I'm saying. That is what I'm saying, okay? So that's why when I said you, as an attorney, write a lot, okay? You write a lot not only to protect the client, you protect yourself, okay? So you memo that, had a conversation with the client, advised that he wanted to do blank with the bodies, told him don't do that, right? Now, if the attorney then says, the client comes to him and says, "Hey, I've done these bad things, here's the bodies," and the guy goes, "What should I do with them?" "Well, you should definitely go dig them up, blah, 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 burn them, whatever." That would be the attorney crossing the line. That would be unethical. Can't do that. Just like if somebody said and said, "Hey, I've done terrible things. Oh, and let me give you the weapon that I did it with," right? The attorney can't hide that. The attorney has to ethically turn that over to the police when they basically come looking for it. Okay? Can't hide it, can't destroy it, can't do anything along those lines. So, and you can't actively participate in counseling somebody to commit a crime, right? They come to you and say, "Hey, Mr. Attorney Man, I want to do something really, really bad tonight." Hypothetically speaking, of course, hypothetically. And hypothetically, I want to do A, B, C, and D. Ooh, the attorney should not say, "Hey, you need to do A.5 and A.6 and 7. Otherwise, you're definitely risking getting caught." You can't do that, okay? And if an attorney were to do that, that would be a problem, okay? So there you go. Hopefully that answers your question, Sarah. I hope it does. Attorney-client privilege is there to, exonerate you of your sins so that you can have a free and open communication and get the best legal advice based upon the circumstances. It's not there to counsel somebody on committing a fraud upon the court. It's not there so that somebody could get away with a crime, so to speak, right? And let's face it, most of the time the attorneys get involved, the facts have been set. The facts have already been set. Just going out to try to find who can find the better facts. That's it. Thank you for staying extra on here tonight to answer that question. Love this community and your team. Well, thank you, Sarah. Appreciate that. It was a good question. And those are the questions we like. It's not just me talking. I'm going to try to answer them. Venus Gal, criminals don't listen to their attorneys? I'm shocked. Laugh out loud. Yeah, just kidding. Yeah, it's true. It's true. That's why we document. So when attorneys say you need to do plan A, based upon my training and experience and seeing this play out 1,000 times before, client's usually going to go do B, completely mess it up, and then say, well, why didn't you tell me that? I did what you told me to do. I'm saying, oh, no. I did not tell you to do that. And, oh, by the way, let me show you my memo to file. Let me show you the letter that I sent to you confirming the plan of action. That's right. That's what we do as lawyers. We write. So it's going to be good. So 3D Babe, I can't wait for this trial. It's going to be suspenseful. Yes, it is. I can't wait. Seriously, when this goes, we're going out there. We're going to go get a seat at the trial. We'll see. All right, we got to go do a Patreon show, ladies and gentlemen. So if you'd like to continue the conversation and you are not already a Patreon, now would be a good time to go and, join us. Become a patron. You can join us. And since we're not out at the CrimeTalk 1 hangar, what does that mean? It means you can call in, ask a question, talk to Scott. Harmless little fuzzball will answer all of your questions. Your local, everyday criminal defense attorney willing to give you the straight advice so you know what's going on in the world. Okay? Thanks for watching. We'll see all our patrons in just a few minutes.